All right. Thank you so much, Mercedes. Thank you to all of you who are with us on today. We're going to, as people are joining in, we're going to go ahead and get started. We are recording this. I'm excited to have Chairman Elgie Sims, who I will introduce in a little bit. The objective today, and before I get to the objective, I want to let you know who's on the back end of things. We have my Chief of Staff, Jeremy Ennis, who will be helping Mercedes, who you just saw, fielding the questions that we will be answering on today. The objective for today, again, before I do that, let me go to a special thank you to my co-hosts of today's town hall. That will be LiveFree Rockford and the Rockford Ministers Fellowship, two community organizations that are advocates for ending racism in our state and criminal justice reform. So what's today's objective? Today's objective is to speak facts straight from the source concerning the rhetoric that you've been hearing, the different things that you may have seen on Facebook. Senator Elgie Sims is one of the co-sponsors and the co-chairman as well of the criminal justice pillar. So I'm excited to have him on today. The second objective of today is to answer as many questions as we can up until 7:30 p.m. This is our time to get in front of the constituents to answer as many questions as we can. This town hall is being recorded, and so it will be added to my website, where you can also find the first town hall where I had Representative Chairman Justin Slaughter, who's the chair of the Judiciary Criminal Committee back in January, along with other videos dating back to August 2020. You can find those videos, and you will find this one at www.staterepwest.com/empowerment. The reason why I focused on this legislation is focused not just on ending racism in Illinois, ending systemic racism, but it's also focused on the one thing that I've been sharing with my constituents here. And I've been making sure that I stay true to my talking points my personal talking points is that it's focused on community empowerment, empowering our community, all communities in relations to our criminal justice system. If one community does not feel empowered, then we should all band together to ensure that that community is feeling empowered. And that's what we're trying to do. That's what we did in this bill. This legislation was worked on for countless hours under the leadership of Senator Elgie Sims, who served as the co-chair, along with Justin Slaughter. And I'm excited to have him with me to address to my constituents here in the 67th District and to everyone in the Rockford region and throughout the state, if you've joined us from other places, to understand the transformative change that can be difficult to adopt. And it's happened in history, and this is one of them. But with the facts that we are going to give you on today, my hope is that I believe I can say Senator Sims' hope is that you are more informed of what this legislation does rather than influenced. So when it comes to Senator Sims, he is the current state senator of the 17th District. He's been in that role since 2018, and before that, he for 8 years he was in the House. So he has a lot of experience in the General Assembly. He's currently the chair of the Appropriation Committee, but while working on this legislation, he served as the chair of the Criminal Law Committee. He's currently in this 102nd General Assembly, the vice chair. Senator Sims continues to put families and communities first. During his time in the Illinois General Assembly, Senator Sims championed legislation focused on improving the quality of our schools, strengthening the middle class by creating good-paying jobs and economic opportunities, bringing fiscal discipline to Springfield, and passing common-sense public safety initiatives with the aim of making our streets safer. Now, I'm excited to have him here because I can only imagine that he's been going virtually throughout the whole state with other representatives and senators to answer questions in their geographical area. And now he's up here with us in Northern Illinois. And so, Senator Sims, thank you so much. I'll give the floor to you before I go to the next slide.
Thank you so much, Chairman West, and I appreciate you inviting me here to this very timely discussion, because it's getting rid of and refuting the mis and disinformation campaign is critical, because understanding the true tenets of the Safety Act is what these conversations are all about. And you're absolutely right. I've been crisscrossing the state. Yesterday I was in Waukegan. Today I was in East St. Louis. Now I'm with you in Rockford. So we're out talking to individuals because we want folks to understand what progress means and what it looks like. And these conversations are so critically important to that effort. So I'm certainly looking forward to this discussion about this very comprehensive pro-safety, pro-reform, pro-community piece of legislation. And what's different about this moment with the Safety Act is that the community had a seat at the table that they've never had before. Individuals, and as you mentioned, Leader West, that there were countless hours that took place. One of the criticisms that you will hear from the other side is that the Safety Act passed under the cover of darkness. Well, the Safety Act took place at the end of, after 9 public hearings that included testimony from countless witnesses about best practices, experiences, etc. 9 public hearings, over 30 hours of testimony, and between the very first day, we had the very first hearing on September 1st, and the time that the first bill, the first draft of this bill was introduced, January 5th, was 126 days. So during that time, we continued to negotiate, we continued to talk to people, by the end, and so again, there's this narrative that this bill was never changed. This bill there was never a chance for individuals to weigh in. 43 changes were made to this bill over the course of us getting this piece of legislation from introduction to final passage. So we have made countless changes. We continue to negotiate even up until the night of passage of this bill out of the Illinois Senate. We passed this bill. Yes, we passed this bill, about 3 o'clock in the morning, 3 or 4 o'clock in the morning, because we continue to negotiate. Even then, we continue to negotiate, trying to bring people to the table to have this discussion, because we wanted input about something that was going to make our communities more safe, was going to bring accountability to law enforcement, will make our criminal justice system more fair and equitable. But what was also important, and that's why it's called the Safety Act, because it talks about safety, accountability, fairness, and equity. But what it also talks about is this happening today. We are not talking about these changes happening in some other time, in some other place. They need to happen today. Communities were calling for it. They were clamoring for it. And, oftentimes folks they feel like the incident with George Floyd is really what kicked this off. For the members of the Illinois Legislative Black Caucus who spearheaded this effort, that was not the point that kicked this off for us. We have been fighting for these issues for years. During my time, and Leader West, you mentioned my time in the Illinois House. During my time in the Illinois House, in 2015, along with now Attorney General, then State Senator Kwame Raoul, we passed the body camera bill. That bill allowed for protocols for body cameras to be used in the state of Illinois. Back during those negotiations, we talked about a number of the issues that are included in the Safety Act. We talked about the elimination of qualified immunity. We talked about the elimination of sworn affidavits. We talked about issues related to use of force. Then fast forward in 2017, we passed the Bail Reform Act. Myself and then State Senator, my predecessor in the Illinois Senate, State Senator Don Trotter, passed the Bail Reform Act of 2017, which was the precursor to the Safety Act, and it allowed for detention decisions to be made based on nonviolent offenses and violent offenses. Now, again, fast forward to the Safety Act. Now we have a law in Illinois, making Illinois the first state in the nation that makes pre-trial decisions not based on a person's ability to pay, but on the person's threat to public safety or whether or not they were going to fail to appear in court. Now, let me pause for a moment talking about the end of cash bail. because some folks believe that by removing cash bail, it means that the doors to the county jails will fly open. That's not true.
Right.
Now, judges will have the ability to make decisions based on a person's threat to the community, threat to a person, or whether or not they won't appear in court. We oftentimes you hear the example of Kyle Rittenhouse. Kyle Rittenhouse has a money bond. He had a money bond of $1 million. He had some of his right-wing supporters pay that bond. But what happened? He then disappeared. He did not adhere to the rules that the court set out for him. They couldn't even find him. Under the Safety Act, a judge would have the ability to set conditions for a person to get treatment, set conditions on whether or not the person has to report. The judge sets all those conditions. Or in the alternative, if the person is a threat to public safety, the judge has the ability to hold them in custody. So the Safety Act, does not depend on the size of your bank account. It depends on your threat to public safety or whether or not your threat to not appear in court. So this is, and there are so many other tenets of the Safety Act. The modernization of our sentencing laws and the institution of a certification and decertification system for law enforcement officers, the statewide requirement of body cameras. For Rockford, the requirement that officers have to live in the city of Rockford if they are going to be law enforcement officers in the city of Rockford. So there's a residency requirement. We reformed crowd control responses and amplified law enforcement training standards and invested in mental health for officers and talking about connecting substance abuse treatment and treatment with first responder duties and creation of co-responder models, the elimination of chokeholds. This is again one of the most comprehensive criminal justice reform measures that have ever passed in the country. One that has been modeled by other states and been examined by other states who are looking to improve the quality of their public safety systems. But for Illinois, it allows us to reimagine what public safety really is. And that's what the Safety Act is all about. It's about reimagining what public safety is, not thinking that public safety is a situation where we lock someone up and that's what makes us safe. That does not make us more safe. We have tried 40 years of mass incarceration, over-incarceration, and under-resourcing individuals. Our criminal justice system does not make us more safe. If it is only related to the incarceration of individuals. We have to prevent and invest in those alternatives to sentencing on the front end. So, in Representative West, I appreciate you talking about community empowerment, because that's how you divert individuals from the criminal justice system in the first place. The criminal justice system sits at the end of failures of all other systems. That's why the Illinois Legislative Black Caucus engaged in a discussion of a holistic approach to how we were going to rid Illinois government of systemic racism. And we looked at the criminal justice system because the criminal justice system sits at the end of failures in the education system. Because if you don't properly educate our children, they end up in the school or prison pipeline and in the criminal justice system. If an individual has a substance abuse or mental health disorder, they oftentimes end up in the criminal justice system. If an individual is economically insecure, they oftentimes end up in the criminal justice system. So we want to reimagine what public safety looks like, investing in those other areas and making the criminal justice system one that's not based on criminalizing poverty, but one that addresses all of the other challenges and issues. So I'm so looking forward to this conversation tonight, Leader West, and I appreciate you having me. I'm ready to get to those questions and get to the rest of the presentation.
All right. Well, thank you, sir. I appreciate that. Before we get to the questions, some of my constituents wanted me to address it, and I'm just thankful to have you on board to help me address this photo that's going around. And I'm not bringing this photo up to shame anyone. I won't even mention who it's from, but a lot of our people who's on this Zoom call and others who are on Facebook or social media, you've seen this image. So Senator Sims, are you okay with us going row by row?
Yeah,
give an explanation? All right. So
Absolutely.
For those who may not be able to see it, let's talk. I'll read it off as I see it. It says critical situations. There is an active shooter at a local high school. Police arrive and the suspect flees the scene. Uniformed officers catch up to the suspect, who is still armed, no longer actively shooting and forcibly resisting arrest. The officers know who the suspect is, and he could be identified and apprehended at a later date. Officers cannot use force against the suspect, even though he just shot people moments ago. That's what people feel this language in the Safety Act is saying. What do you say about that, Senator Sims?
Leader, that is absolutely false. There is nothing in the Safety Act that prevents law enforcement officers from using appropriate threats or using appropriate force against an individual who poses an imminent or even an imminent threat, or even a threat of serious or deadly bodily harm. There's nothing in the Safety Act that prevents that. If an individual is a threat, then the law enforcement officer can use the appropriate amount of threat force against the individual. So, and that's, you will hear me, and you will hear supporters of this legislation talk at length about the fear mongering, talk at length about the mis and disinformation campaign. This is a critical example. This is a perfect example of that mis and disinformation, those mis and disinformation campaigns. This is fear mongering at its worst. Individuals should, and what the Safety Act does is it allows for and calls for law enforcement officers to use deadly force in a way that recognizes the sanctity of human life. Page 283 of the bill talks about the sanctity of human life. And it also talks about using force, and on the law enforcement officers, when they do use force, recognizing the totality of the circumstances. The law enforcement officers, they come into contact with some very difficult situations. I recognize that. As we crafted this bill, let me pause for a moment and give kudos to, I know you had Chairman Justin Slaughter on previously, who worked tirelessly at my side. He was my partner in progress, as was State Senator Robert Peters, who was Representative Slaughter, the chairman of the House Judiciary Criminal Committee, Senator Peters, the chairman of the House or the Senate Public Safety Committee. We worked tirelessly on these provisions, trying to understand, but making it clear as we hear from constituents that they just wanted their lives valued. Yesterday in Waukegan, we heard from a mother, mother of Mr. Justice Howell. Justice Howell was shot twice in the back during an encounter with law enforcement. And what we want from law enforcement is to recognize that when they make those decisions, and again, those are oftentimes split second decisions. But what we also want them to do is, when they make those decisions, to make those decisions looking at the individual on the other side of those decisions as a human, and recognizing and protecting their humanity, and not seeing them always as a suspect or someone who is a violent actor, but recognizing the totality of the circumstances, and that every individual is not a suspect. But this first scenario, that's not accurate. That the law enforcement officers could not use force. They could absolutely use force. The Safety Act regulates the use of deadly force.
Gotcha. Thank you so much for that. I'll go down. Disorderly conduct. This one says, you own a local store and an individual is causing trouble. The suspect is being loud and yelling obscenities at customers. Police arrive and realize he's disturbing the peace of the store. The suspect will be issued a ticket, a court date within 21 days, and officers will leave. The suspect cannot be forcibly removed, and the store owner is left with the same problem. Is that what the bill does, sir?
Absolutely. Again, no, it's not what the bill does. What disorderly conduct is it's a Class C misdemeanor, which is a non-violent misdemeanor. So what we're trying to get to is treating individuals who are nonviolent differently than we are treating violent offenders. You know, incarceration and incapacitation is reserved for those individuals who are threats to public safety. Under this scenario, if an individual were an obvious threat to the community or any person, law enforcement would still have the ability to arrest that individual. But if the individual does not pose that threat, then if they are a threat to the community or an individual person, they still have the ability to arrest that individual. What we're trying to get to again is reimagining what our public safety system looks like. We have tried this system of when a problem arises, we immediately go to arrest, as opposed to I've heard a very good friend of mine say this over and over again, who is in law enforcement. Law enforcement officers should be problem solvers. When they come to a scene, that's why we have tried to invest over the reform efforts that we've the last several reform efforts. We've placed a huge premium on investing in de-escalating situations. Mm-hmm. So having law enforcement officers, as opposed to seeing every situation and every circumstance as one that should lead to an arrest, how about we de-escalate situations and problem solve and talk to individuals as humans, talk to them not as suspects, talk to them as individual people. And you would find that when people are treated with respect, how much respect they will have for the system.
Thank you for that. The next one says criminal trespass. You arrive home and notice an unknown person sitting in your backyard. You call the police and wait for them to arrive. The police confront the suspect. The police confront suspect and he refuses to leave. The individual cannot be arrested and no force can be used to make him leave. Only a ticket can be issued. This sounds kind of like the previous one. Would you say?
It absolutely. It's more of the fear mongering that's going on to try to stop the progress that we're making. This scenario that's laid out clearly ignores the provision of the law that gives a law enforcement officer the ability and the discretion to respond to individuals who pose a clear threat to the community or person. That is clearly in the law, that if a person is a threat, so the law enforcement has the ability to respond and arrest in kind. Again, this is what you are finding. And let me pause again for a moment, Leader West, and talk about the fear mongering. Because as you and I have talked about this law, and our colleagues have talked about this law, this was a difficult process. Change is often difficult. James Baldwin once said that not everything faced can be changed, but nothing can be changed unless it's faced. We've got to get to a place where we have these very difficult discussions. What you are seeing with the fear mongering and mis and disinformation campaign that's going on is individuals trying to stop progress from happening, trying to stop reform from happening. So if you politicize the discussions that we have had, politicize the law that is making progress and will make Illinois safer, it will make reform efforts in the future much more difficult. That's not where we are. That's not what our communities are calling for. That's not what constituents are calling for. There was a poll done several months ago that talked about that asked questions relative to individuals and what they wanted in terms of reform in police practices, reform for how individuals deal with perceptions of law enforcement violations of individuals' constitutional rights. Illinoisans overwhelmingly, 80-90%, support reform in criminal justice, in the criminal justice system. They support individuals being held accountable for violations of an individual's rights. That's what the Safety Act is all about. And knowing those things, some of the opponents are trying to politicize this moment so that we never get to a reform discussion in the future. Well, I can tell you that because the communities, advocates, supporters, they want reform in the state, and they are activated in a way that I have never seen before. And it is one that the reform movement continues to go. And the Safety Act, House Bill 3653, is one point on that reform movement, that reform journey. But it's going to be a journey that makes our communities more safe, but it also brings equity and justice across our criminal justice system.
Thank you for that. The last one, and then we'll move on to questions. Police are investigating a homicide. A body is on the ground, and the area is surrounded with crime scene tape. A person decides to enter the area after being told not to by a uniformed officer, walks through the crime scene and jeopardizes the investigation. This person will no longer be arrested for obstructing a police investigation, and force cannot be used to remove the individual from the scene. What do you say about that one, sir?
That's a flat out mischaracterization of the Safety Act. The Safety Act does not prohibit an officer from making an arrest in the described circumstance. An individual certainly would be allowed to make an arrest. What I believe the confusion is with this provision of the law is that we changed the law and added a provision that says an individual could not be arrested merely for resisting arrest. So if you must have an underlying charge to be arrested for resisting arrest. You see too many people across the state of Illinois are sitting in county jails or sitting in police stations because they were arrested for resisting arrest when they weren't being arrested for anything else other than resisting arrest. So the provision that I believe they're talking about is in the obstruction of justice or obstructing of a police officer section of the law. But nothing in the Safety Act will prohibit that a law enforcement officer in that circumstance from arresting an individual in the circumstance described. Again, that's the mis and disinformation campaign that we continue to talk about. Falsely spreading information that the Safety Act does things that clearly it doesn't.
Well, there you have it, folks. Thank you for that, sir. I wanted to make sure people saw this and heard this straight from the source. And the information that you receive will inform you and not influence you. Like I said earlier, transformative change can be difficult at times, but we are here to answer any and all questions and concerns so that we, as a community, we can move forward. So let's move on to questions. Let me stop sharing my screen. Oops. Can we come back here? Okay, done sharing my screen. All right. So Mercedes, what would be the first question that you have?
First question that we have, it says, what determines posing a threat to officers?
I guess I'm confused about posing a threat. I mean, it could certainly be it could be a verbal threat. It could be a physical threat. I don't know. I guess I don't know exactly what the individual is asking for, but it would really depend on the situation. So an individual could be verbally abusive to a law enforcement officer, or they could be physically abusive. So physical abuse, in my opinion, would be anything that would lead to the striking or harmful or offensive touching of a law enforcement officer, which is very different than verbal abuse. But not that it's any less harmful, but it will be different. But so I guess it really depend on what the situation and circumstances called for.
To the individual who asked that, if you want to go into detail and elaborate on your question, that would be great.
Thank you for that. The next question asks, can you talk more about bail reform pertaining to this bill?
Absolutely. For the last several years, since we passed the Bail Reform Act of 2017, I've been working and served on a commission along with several of my legislative colleagues, including one from each caucus. So Representative Leader Carol Ammons from the House Democrats, Senator John Curran from the Senate Republicans, and I think Representative Patrick Windhorst from the House Republicans. And we have been sitting and working with, and prior to that, Senator Scott Bennett from the Senate Democrats also sat on the commission. And we worked on pretrial issues with the Illinois Supreme Court, trying to figure out how and what the pretrial decisions would be made, because we were trying to address those circumstances that would lead to decisions being made where an individual be held on a pretrial basis. And because I would remind our listeners that at the pretrial phase, an individual has not been found guilty. They are still entitled to being innocent until proven guilty. The threshold question is whether or not they are a threat to public safety. And we, as we talked about earlier, you still have to make decisions about whether or not an individual is that threat, or whether or not an individual can be released on a pretrial basis. So if a judge were, say for instance, I'm going to talk about a case that we examined during the passage of the Bail Reform Act. There was an individual. She was mentally ill. She was homeless, and she was pregnant. She went into a convenience store. She stole several pieces of fruit and several pieces of candy. This had happened several times before. So she was caught. Police were called. Police show up at the scene. The police recognized that the woman was mentally ill. They recognized that she was pregnant. The police officer, and this is why, I always say that you can support good police officers and be pro-reform, because this officer was clearly a good officer. The officer came on the scene, recognized all of the challenges, said to the store owner, "Sir, I don't think this woman should be arrested." The store owner said, "No, she's got to be taught a lesson." Again, this is the mentality we're trying to get away from. She's got to be taught a lesson. Police officer comes back to the store owner again, says, "Sir, I will pay you for the items that the woman stole." Again, the store owner says, "No, I want her arrested." Officer, complying with the crime victim's wishes, takes the woman into custody. The woman goes into custody. As I mentioned, she was homeless, mentally ill, and pregnant. She sat in county jail for 163 days. So 163 days. I mentioned she was pregnant. So what happened while she was pregnant? She had the child. She had the child while she was pregnant. So now the county taxpayers are on the hook not only for her being incarcerated for those 163 days. They're on the hook for the health care for the child, when a more appropriate response, clearly because this young woman had the mental health challenges, she was housing insecure, she was economically insecure, a more appropriate response would have been for the judge to say, "You know what? I'm going to direct this young woman into mental health treatment. I'm going to direct this woman into a community placement where she can get the help that she needs. She can get the prenatal care that she needs." And that would be a more appropriate response as opposed to incarcerating her, having the baby in prison, then having the child then go into the child welfare system, the DCFS system. How does that make us more safe? Those kinds of decisions don't make us more safe. We have got to reimagine and think differently. There's a saying, doing the same thing and expecting a different result is the very definition of insanity. The reason we are in our mass incarceration problem right now is because we believe that the only way to make us more safe is to just incarcerate people. Oftentimes we are incarcerating people we're angry with, not the ones that we're afraid of. And that's the exact situation here. So our bail reform allows us to make decisions, allows judges to now make decisions based on their best judgment and placing people in the appropriate care that will allow them to get the help that they need, as opposed to being locked into inside of a county jail, or in the alternative, being able to post money bond without having any conditions. So in the alternative, let's play this out. You have an individual who has been hired to be a drug enforcer, and he's caught, committing a crime. He's caught firing a weapon. Judge gives him a bail of $100,000. Well, he's got access to cash. This is a violent individual. Judge sets the bail at $100,000. He walks out. He's had somebody come in and pay the bail is $10,000. One of his drug conspirators comes in and pays the $10,000. He walks free with no conditions, with nothing that says he's held because he's shown to be a threat to the community. He's thrown to be a threat to public safety. That person can just walk free. The Safety Act, under the Safety Act, the judge could say, no, I'm looking at your priors. I'm looking at a verified risk assessment that says you are a threat to the community, and I'm going to hold you in custody until your court date. That is how we reimagine public safety, and we make decisions based on true community safety. And that's what the Safety Act does.
Awesome. Thank you for that, sir.
Yes, sir.
Go ahead, Mercedes.
Hello? Can you guys hear me?
Yes.
Okay. So our next question talks about, under the law, about resisting an officer is a guilty conviction. And is there any steps that can be taken to address this?
Say that one more time.
Yeah, say that. I don't know if I understand.
So it pertains to, under the law, about resisting an officer and how it is a guilty conviction, resisting an officer. If there's any steps that can be taken to address this, that way it cannot be considered a guilty conviction when you resist an officer.
I'm assuming resisting arrest. That's what I'm assuming.
Yeah,
yes.
I'm assuming that's a resisting arrest. But if it's a resisting an arrest, and resisting an arrest under the law right now, if you're convicted of resisting arrest, that falls under the statutes. I guess I'm not really understanding the question. I apologize. Maybe if the questioner could tell me what the question is, because I don't understand. I'm sorry.
Well, what we'll do, for the individual that asked that question, can you provide more clarification? We'll come back to that. The next question asks, can you explain how the Safety Act defines how complaints against police officers are handled?
Absolutely. So there are what we found as, and there's another narrative out there that this bill just came about without investigation, without research, without looking at best practices, which is, again, nothing could not be farther from the truth. We talked to numerous police departments across the state, local police departments, county police departments, and we looked at some best practices. And there were instances where individuals were allowed to report on an anonymous basis complaints against law enforcement officers to superiors. So in the Safety Act, we codified that practice. Now we allow for individuals to now be able to make complaints without having a sworn affidavit. What individual community members were saying is they were having complaints and negative interactions with law enforcement officers, but having a sworn affidavit that they could in some ways prior to the passage of the Safety Act, they could be charged with a crime. It had a chilling effect on individuals who would go and report police officers. So individual community members and advocates were saying to us that reports were not being made against law enforcement officers because people feared retribution. So what the Safety Act now does, it allows for an individual to not have to sign under the penalty of signing a sworn affidavit, to now make a complaint to the superior of a police officer, so that when a complaint happens, they can make that complaint anonymously for it to be followed up on. Now, once the investigation happens, if it's founded, if the investigation happens and nothing comes of the investigation, nothing goes into the police officer's permanent record. However, if there is an investigation and the allegations are founded and they're found to be true, then those actions go into the police officer's permanent record for additional action against the officer, but only once the investigation is completed and it's found that an individual has violated a person's rights or violated departmental policy. But that only happens after investigation happens.
Let me ask a follow-up for you, sir. I talked to some law enforcement in my community. Their fear of that is anyone and everyone can anonymously file a complaint, and it jeopardizes law enforcement's employment if the complaint is false, or if the complaint is in retaliation to an arrest from a clean arrest from the law enforcement officer. Can you shed light on what the fear of our law enforcement officers, because it's a valid fear. Should there be any fear of anonymous complaints from the community? Absolutely,
it's an absolutely valid fear. However, it's not founded in this circumstance. Right under the Safety Act does not allow for every complaint against a law enforcement officer to find its way into their officer's record. So your local law enforcement officer can rest assured that not every complaint that's made, every frivolous complaint, is not going to find its way into their permanent record. So they can put those fears aside. I understand that they're concerned, but those fears are unfounded because that won't happen. The only time a complaint will find its way into a person's permanent record if after an appropriate investigation, it is determined that the person's rights have been violated, or the officer has violated departmental policy. That's the only way under the Safety Act that violations of an individual's violations by an individual officer will find their way onto their permanent record. So even though every complaint will be investigated, which is again what we were finding from our research, that was best practices. So all investigations are investigated. The same is true here. So so every complaint will be investigated, but if it's determined to be frivolous, it will not find its way into the officer's permanent record. If it is determined to be frivolous, it will find its way into their permanent record. If it is determined to be founded, it will find its way into their permanent record. I'm sorry, I misspoke.
Our next question asks, how will the investigators of the officers be regulated?
We have, that's a great question. We've went to great lengths to invest in bulking up the Illinois Law Enforcement Trainers and Standards Board. In the governor's introduced or recommended budget for fiscal year 2022, he included significantly more resources for the Illinois Law Enforcement Trainers and Standards Board to do the investigations, to do the decertifications. We are still working with the board to outline the appropriate resources necessary for the additional activities that they are going to be responsible for. In addition to being the repository of the certification and decertification, there is going to be additional work that the Law Enforcement Trainers and Standards Board will have to do for training. So there are additional training requirements. So there's going to be additional investments made in the board to make sure that that process is beefed up and they are able to accommodate the additional activities that they're going to be charged with. We've got some individuals on the LiveFree board and the leadership of the board who have a law enforcement background, the members of the board, And that's another thing that does not get enough coverage in the tenets of the Safety Act. What we've talked to community members and advocates from across the state, and what they were asking for and calling for were community members to be involved in these decisions. So we're including in the decertification and certification panel the ability for community members to be a part of that process. So there will be community members appointed to that board who will have a say in these discussions. This is, again, that's why when I talk about this being a pro-safety, pro-reform, pro-community sweeping piece of legislation, it really is, because it takes all of those issues into consideration.
Okay, our next question asks, it says, is it true that anything that goes on a police officer's record doesn't follow them from state to state? And then a follow-up question to that says, if so, are there certain legislations that can be passed or written to address this issue?
Let me start with the last question first. Yes, but that will require federal legislation, not state legislation. What we built into the Safety Act was a certification and decertification process where when the officers would do what's called lateral hiring. So if you were to move from one department to another department, law enforcement management of the new department is required to look at the record of the individual, not just their background, but they have to look at the database databases that are now created. What we would have to do is have a national certification database, which again, that will require some federal legislation. That's certainly not, and that you have heard some of those items be talked about. So I am encouraged by that. The U.S. House took some action just yesterday on the George Floyd Act, which calls for some of these measures. So I'm looking forward to those discussions continue to happen at the federal level. But I think that's one where we should as citizens talk to our U.S. representatives and make sure that they understand that how important this is for us.
So our next question, the individual who had asked the question before, they provided a little bit more information. It says, okay, so the law does not currently allow for court supervision for resisting a police officer, resisting arrest. Court supervision is a term that allows a guilty plea to enter, but not a conviction to enter if it goes on your record. Right now, only a conviction is possible, either conditional discharge or probation. Can the legislator create supervision for the crime of resisting arrest?
Okay, thank you. I appreciate that clarification. Now I understand better. That certainly something that we could entertain. As I've mentioned, the House Bill 3653 is not the last reform measure that we will pass. I would expect there will be other reform measures that will pass, including in the spring 2021 session. So I would say this is an issue that I would certainly love for you to reach out to Representative West or myself, and we'll follow up on that and get some ideas. That's real, and that's how the Safety Act came together, from discussions just like this. Well, people would come with ideas, they would come with suggestions, and we were able to take those suggestions and turn them into law. That's what makes the Safety Act so much different than other reform measures in the past, because community members were not just sitting at the table represented by their elected officials like Representative West and myself. They were actually at the table. That's why you find, let me go back to bail for a minute. You find domestic violence advocates, you find crime victims advocates, you find sexual assault victim advocates, all sexual assault survivor advocates, all saying that they support the Safety Act. They support the Safety Act because they recognize that it makes them more safe. It makes individuals who are victims of and have survived crime in its worst forms, whether it's domestic violence or sexual assault or violent crime, they recognize that the Safety Act and the provisions that will allow judges to make decisions based on whether or not a person is a threat to the community, a threat to a person, or whether or not they're not going to show up and appear in court, as opposed to the size of a bank account, that makes our communities more safe. I think that's critical. And that's, and Leader West, that's a point that I could not let this discussion end without pointing out, without making. We've talked a lot about the individuals who are opposed to this, but I've not talked a lot about the individuals who support it. Right. And the individuals who support it are folks who are crying out and saying, I come to these discussions in some of my lowest times. That Mrs. Howe, who shared the story of her, as I talked about earlier, who shared the story of her son, losing her son through his interaction with law enforcement officers. She came and she said, she called for us to do something, not just do something, do the right things. Right. And the Safety Act is the right thing. And you have survivors of domestic violence. They're saying, protect individuals who are being victimized by their domestic partners. The Safety Act does that. So individuals who are being sexually assaulted, protect us. Then you will find that they support the Safety Act because it makes us more safe.
Okay, and then we do have one last question. One moment. Representative West, did you have a question?
I'll go last. This anonymous question, go ahead and go. Do you see it?
Okay. Oh, yep. Sorry, I think my mic was acting up. Would you support judges and jury members not being able to see or know the race of defendants to help fight discrimination?
I think that we are at a place and a point where I certainly look forward to the day where we are in this post-racial society. I think about where we are, but there was a quote from Franklin Delano Roosevelt that we must remember that any oppression, any injustice, any hatred is a wedge designed to attack our civilization. When we look at individuals and the color of your skin is the only crime that you have, it drives a wedge in right down the heart of our communities. I want to believe that we are on the path towards an area or towards a time where we are having these reckonings, and we have moved past looking at race or gender or who you love and making decisions based on when our criminal justice system based on individuals, whether or not they're safe, they're a threat to our community, or they have committed a crime, not because they're poor, not because they are economically insecure, not because they have a mental health challenge. I believe we are on the path to a circumstance where we invest in, and we have a criminal justice system that looks at making our communities more safe. But part of that path and that journey requires us to do some work also. It requires us to challenge assumptions that we have. When you see a person who looks different from you, don't look at that person as a thug or as a hooligan. The NAACP did a report some years ago that was titled "Born Suspect," and that report talked specifically about the interactions that people of color have with the criminal justice system. We've got to get past a circumstance where we look at individuals and immediately we think criminal. Immediately we think violent. I've been a Black man all my life, I've had both negative and positive experiences with the criminal justice system and with law enforcement. But But I remain optimistic that we are still on that path towards a system that's more equitable and more just. And that journey started with the passage of the Safety Act.
Well, we're at 7:28. Senator Sims, brother, I appreciate you. I have one more question for you.
Yes, sir.
What's next? What do you need as a leader in this fight in our General Assembly? What's next in terms of this 102nd GA or even the spring session? What do you need from me as I interact with my constituents? I had a conversation with people telling them that I'm here still to listen. So what's coming up around the bend next?
Well, what I would ask from you and from your constituents is to recognize the information that they got here today, the information that we talked about, and go out and share that. Share the information that that the misinformation and disinformation that they're hearing is not fact. It is not an accurate depiction of what's included in the Safety Act, but it is an attempt to politicize public safety. And that's where we are at this moment. This has stopped being about policy and has started being about politics. And that's what's so difficult in this moment, because public safety is not a political issue. It is an issue about making communities safe. It's an issue about providing communities what they need to have the quality of life that they deserve. And so from you, Leader West, I would ask for you to continue to be a leader, be the leader that you have been on these issues, bringing your perspective and this perspective of the large metropolitan area, but also a rural area, to Springfield, and making sure that individuals recognize that all communities are different, and that we have not every situation, not every circumstance requires a penalty enhancement, right, but it requires us to be smart on crime and make sure that we are living up to the statements of the Illinois Constitution, that we return individuals to their fullest usefulness when they have gone through the criminal justice system. We recognize that individuals, when they come into contact with the correction system, they should return better. We should be correcting behavior. They should return better after they've gone through the system, as opposed to more broken. And I appreciate and continue, Leader West, to demonstrate that leadership in the Illinois House and in the Illinois General Assembly, to talk about our focus on making people better, because that's what our actions are all about. And thank you for sharing this opportunity for community members and constituents to learn the truth. Don't just go to Facebook and hear mis and disinformation, but to come and I appreciate anyone and everyone who actually took the time to participate this evening, because that means you care. That means you have a vested interest in making our state better. I have often said that the Safety Act is not just about the Illinois that we are, it is about the Illinois that we strive to be. And in your leadership in these efforts, Representative West, have been critical, and they will help us to make sure that we continue to pass policies that will make our state safer, will make law enforcement officers in our state more accountable, and will make our criminal justice system more fair and equitable. And again, happening today. So I thank you. That is absolutely what, from you, I think we continue to need, is your leadership, your guidance, your sound common sense approach to these efforts. So thank you. So that is what we need, your continued leadership. Awesome. Leader.
Chairman Sims, thank you, sir. And I appreciate your leadership. And I'll be, ever since I got into the General Assembly in 2019, you've been someone that I've been watching, trying to figure out how to be an effective legislator. The true definition is Senator Elgie Sims. So thanks so much, my friend.
Thank you, my friend. I appreciate that, brother.
To all of you who are still on the call, thank you for joining us. Again, this will be on the website, staterepwest.com/empowerment. I'm here for any other follow-up questions. Feel free to email my office assistance@staterepwest.com if you have any follow-up that you want to discuss, because I want to make sure that you're informed, not influenced. Senator Sims, Mercedes, Jeremy, thank you to all of you. Everyone have a good night.